What is doxing, and is it a criminal offence in Australia? This is a question that has recently risen to prominence in the wake of leaked chat logs from a pro-Israeli WhatsApp group. The Albanese government is proposing new criminal offences for doxing, a term that refers to the act of revealing and publishing private or identifying information about an individual on the internet without their consent. This proposal follows the release of these chat logs, which led to a wave of criticism, support, and concerns about anti-Semitic harassment and death threats against Jewish Australians. In Australia, doxing could potentially lead to the criminal charge of using a carriage service, which includes the internet, to menace, harass, or cause offence under Section 474.17 of the Criminal Code Act 1995, which carries a maximum penalty of 5 years in prison. But while this can encompass some acts of doxing, the prosecution must prove the act would cause a reasonable person to be, it was menacing, harassing, or offensive, which is not always easy to do. The proposed law seeks to criminalize the publishing of identifying information with malicious intent. While pro-Israel activists are pushing for this change, others caution against using criminal law to restrict freedom of speech. They argue that the leaking of private conversations can be a means of holding individuals accountable. However, concerns remain about the potential misuse of such information. In summary, the question of whether doxing is a criminal offence in Australia is a complex one. The Albanese government's proposed law could make it so, but there are valid arguments on both sides of the debate. The balance between protecting individuals' privacy and upholding freedom of speech is a delicate one, and it will be interesting to see how this issue evolves in the coming months and years. Going to court. Call Sydney criminal lawyers on 9261-8881 to arrange a free first conference. Watch our latest video here.